welcome. We're back today to talk more about actual innocence and wrongful convictions. My name is Mark Smith. I'm with the Center for American and International Law, and our guest today is one of the world's leading experts on the subject, Professor Keith Findley. Professor Findley is at the University of Wisconsin Law School. He is a former public defender. He co-founded the Wisconsin Innocence Project, which he co-directed for almost 20 years, and he served for several years as president of the Innocence Network. That's a conglomeration of more than 60 innocence affiliates throughout the world. So he truly comes not just with the experience of this country, but of this world. And it's, as you know, an important subject. We're delighted, Professor Findley, to have you with us, and we're now in your good hands.
Well, great. Thank you so much for that very kind introduction. I'm really happy to be here today to tell you about the Innocence Movement and the work of innocence organizations around the world that has indeed been a mainstay of my professional career for most of the last two and a half decades. To start with, the images like these that are flashing across your screen of wrongly convicted people who have been exonerated and set free are probably fairly familiar to most of you by now, to the point where it's hard to conceive of a time when we did not recognize that there are innocent people in prison who've been wrongly convicted and for whom justice has been denied. But I want to take you back a little bit earlier in history and remind everyone that there was a time, in fact, when scenes like these were virtually unimaginable. If you go back, for example, as far back as 1923, when the very famous Judge Learned Hand wrote in this decision, United States versus Garcon, he wrote, "Our dangers do not lie in too little tenderness to the accused. Our procedure has always been haunted by the ghost of the innocent man convicted. It is an unreal dream." There was this real sense that it was just not realistic, not likely that innocent people were convicted in our system. That was reflected again in this very famous quote from a prosecutor in Worcester County, Massachusetts, who said, "Innocent men are never convicted. Don't worry about it. It is a physical impossibility." That was in 1932. Now, lest you think that was just all ancient history, let's fast forward a little bit. In the late 1980s, some very smart, very astute observers of the criminal justice system, Stephen Markman and Paul Cassell, wrote in a legal journal that the risk of executing an innocent person, quote, "is too small to be a significant factor in the debate over the death penalty." They just couldn't conceive that there were innocent people who had been sentenced to death. Reflecting all that, Professor Marvin Zollman, a contemporary criminologist, reflected that as of at least as late as 1990, very few Americans thought of wrongful convictions as a problem. Most would have said that criminal justice was deficient in not catching, convicting, imprisoning, and executing enough criminals. Not the opposite, I might add. And then, as of 1993, Justice Sandra Day O'Connor from the United States Supreme Court, in a concurring opinion in a case called Herrera versus Collins, reflected that sort of overwhelming sentiment we had when she wrote that our society has a high degree of confidence in its criminal trials, in no small part because the Constitution offers unparalleled protections against convicting the innocent. And so those statements were really very reflective of what happened, of how we viewed our criminal justice system. We often heard people say we have the best system in the world, that our protections for criminal defendants were so extensive that there was just no way that an innocent person could be convicted. That case that Justice O'Connor concurred in, Herrera versus Collins in 1993, was in fact a really important and telling decision in terms of what it reflected about how the court saw the potential for wrongful conviction and indeed wrongful execution. And what happened in that case was this man, Leonel Herrera, had sought to overturn his conviction and death sentence based on what he claimed was compelling evidence that he didn't do it, that he was actually innocent and was going to be executed for a crime that he didn't commit. And what the Supreme Court ruled was that the federal Constitution really doesn't address the reliability or the accuracy of criminal convictions, but really provides a system of procedural protections to make sure that the states have a good chance of getting it right. In other words, the Constitution is concerned about the process, about the fairness of the process, but not necessarily about the fairness of the outcome. And so the court held that, generally speaking, there is no what they called a freestanding due process claim of actual innocence. You couldn't go into federal court and say, please don't execute me, please free me from my conviction because I'm actually innocent and here's my proof. The court would say, well, we'll look at the procedures used to convict you, and if they followed the rules, we're not going to second guess the judgment of guilt or innocence. But the court did acknowledge that perhaps if you could make what the court called a truly persuasive showing of actual innocence, which they didn't and have never yet recognized, then they said, well, maybe under those circumstances, execution of a probably innocent person would violate the Constitution. But without that truly persuasive showing of actual innocence, even execution of a probably innocent person would not violate the Constitution. So that gives you a sense of how the courts viewed the concern about actual innocence as late as 1993. Well, why do we have such a different sense of this problem of wrongful convictions today? Why do we have this widespread recognition that wrongful convictions occur, that innocent people are wrongly convicted, and that we need to be sensitive to the risk of convicting, imprisoning, or even executing an innocent person? And the reason that our view about this has changed so dramatically begins with this man here, Sir Alec Jeffreys, a professor at the University of Leicester in England, who is credited as being the inventor of what he called DNA fingerprinting in 1984. That is, he was the first person to figure out how to take DNA samples and determine the probable identity of the person who left behind the biological evidence at a crime scene. And dramatically, his new technique was used for the very first time in a case involving this man, Colin Pitchfork, also in England in the mid-1980s, shortly after Sir Alec Jeffreys had created this technology. Amazingly, the technology was used simultaneously to exonerate an innocent person in this case and to identify and convict the guilty. It was a case involving two young girls in England who'd been raped and murdered, one in 1983 and one in 1986. And police had a suspect. They initially suspected this guy, Richard Buckland, who was a local 17-year-old youth. He was developmentally delayed. He had learning difficulties, and he was subjected to some intense questioning by police, and he confessed to one of the crimes, to one of the murders. So he was in fact the police's prime suspect, the guy they were going after. But to make sure they had it right, they used this new DNA fingerprinting technology that had just been invented. And they went through the community and they did what we would consider a DNA dragnet. That is, they went around and tried to get DNA profiles from all of the men in these small communities. And they took volunteer samples and they got virtually 100% of the community to contribute their DNA to be tested. And through that process, it's sort of a long story how they finally did it, but ultimately they found that the DNA from both of the murdered girls that had been left behind by the rapist came from this man, Pitchfork, Colin Pitchfork. And so the DNA exonerated Richard Buckland, showed that he was absolutely innocent, even to a crime, one of the rapes and murders that he confessed to, and that in fact the real perpetrator of both was Colin Pitchfork. A few years later, lawyers in the United States began to think, well, this DNA has this amazing potential to determine the truth in cases like we've never seen before. And they thought, well, maybe it has the potential to tell us if we got it right or wrong in old cases. And so they applied it to this case of a man from Illinois by the name of Gary Dotson, who was convicted in 1979 of aggravated kidnapping and rape. He was convicted on the basis of the accusation of a young woman who claimed that she'd been raped, and she picked Gary Dotson's picture out of a mug book, a book of mugshot photographs. Dotson claimed his innocence throughout. Eventually, the victim actually recanted and said she was scared. I believe she was trying to protect for her boyfriend, and she made up the rape allegation and just picked him out randomly as the guy she accused of having raped her. But her recantation was rejected by the courts. They didn't believe her. They believed her accusation, but not her recantation. And so finally, in 1989, they did DNA testing on the biological samples collected from her body, and it exonerated Gary Dotson, I'm sorry, and he became the first person in the United States. That year, there was a second person exonerated by DNA evidence, and every year thereafter, for a number of years, the number of people exonerated with DNA evidence grew increasingly until it leveled off after a number of years and has held relatively steady ever since then. This work was primarily pioneered in the early days by these gentlemen, Barry Scheck and Peter Neufeld, who were very famous lawyers from New York City, who wrote this book along with New York Times journalist Jim Dwyer called Actual Innocence, in which they told the stories of some of the first people exonerated by DNA evidence and the lessons that were being learned from those cases. And this work really launched what we now know of as the Innocence Movement. It began with the creation of the Innocence Project. 3 years after Gary Dotson was exonerated, Barry Scheck and Peter Neufeld created the Innocence Project in New York City, and the Innocence Project today continues to function and is by far the largest and most successful of all of the innocence organizations in the world. 6 years later, as you were told during the introduction, I co-founded the Wisconsin Innocence Project with my colleague John Prey. We looked around at what was happening, and we had this wild idea that perhaps, maybe, we have innocent people in our state as well, our state of Wisconsin, and that maybe we should look into it. So with some trepidation, we founded the Wisconsin Innocence Project. At that point, we were the third such organization. The state of Washington had created a project before us, so it was the Innocence Project and the Innocence Project Northwest in the state of Washington, and then us. I look back at that and have to chuckle, because at the time we were a little embarrassed, a little nervous about creating such a project, because we thought, well, maybe we'll never find anybody who's innocent, and this will all just look silly. But of course, that turned out not to be a problem at all. Once we started looking, we found many, many innocent people and have exonerated many of them. Texas, in fact, our first exoneration that we ever achieved, which I'll tell you about in a minute, was from a case of a man convicted in the state of Texas. And why did we reach down into Texas to handle that case? Well, because at the time, Texas had no Innocence Project or no innocence organization. Today, Texas has 3. It has the Innocence Project of Texas, based in Fort Worth, the Actual Innocence Clinic at UT in Austin, and the Thurgood Marshall School of Law Innocence Project in Houston. All 3 of them actively working on these kinds of cases. And as Mark told you at the beginning, this is now part of an international movement where all of these innocence organizations, they're all actually independent organizations, but they all came together to form an affiliation, which we call the Innocence Network. And we have nearly 70 such projects in the United States and indeed around the world now. So 50, some of them are in the United States, and the remainder are in other parts of the world, all working together to try to correct these injustices, but also to learn the lessons from these cases so we can improve the system. One of the best ways to help you understand these projects, the work they do, and the nature of the problem is to probe a little bit into a few examples. And I mentioned that the first case that we at the Wisconsin Innocence Project worked on was a Texas case. It was indeed, and it was the case of this young man, Chris Ochoa. This is a picture of Chris with his mother in El Paso, Texas, where he grew up. After he graduated from high school, and Chris, by the way, was sort of your all-American kid, never been in trouble with the law. He was the editor of his high school literary magazine. And when he graduated from high school, he wanted to take a little time off before he went to college. So he moved to Austin, where he got a job at a Pizza Hut. And about the time that, while he was working at that Pizza Hut, a young woman by the name of Nancy DePriest was a manager at a different Pizza Hut in Austin. And she went into work one day by herself into the Pizza Hut store. And while she was preparing the restaurant for that day's business, someone gained entrance into the store, proceeded to attack her, bound her, raped her, shot her in the head, and left her to die. She never regained consciousness. Police never had any eyewitnesses, no real leads. So what they did was they told store employees that people who commit this kind of crime often like to come back to the scene of the crime, so be on the lookout for anything suspicious. A few weeks later, Chris and his roommate, a guy named Richard Danziger, who also worked at another Pizza Hut in town, were curious. This case had gotten a lot of media attention in Austin. This was 1988. They'd gotten a lot of media attention in Austin, and being employees at another Pizza Hut particularly struck home for them. So they went to the restaurant where this crime had occurred, and the security guards saw them drinking a toast to the memory of Nancy DePriest, and then thought it odd that they came up to him and asked him questions about the status of the investigation into the crime. That was all it took. So the security guard wrote down Chris's license plate number. Based on that, police picked Chris up, took him into custody for interrogation. Chris was a very nervous young man just by nature, by his character, and police mistook that as a sign of guilt. And they quickly decided he must have been the guilty party, and they proceeded to interrogate him in a very rigorous, accusatory way for 12 hours straight in two different days, at the conclusion of which they got Chris to sign this single-spaced 5-page confession, rich with details of the crime that one would think only the perpetrator of the crime could have known. So on the basis of that, Chris was convicted. He pled guilty in order to avoid the death penalty. He was sent to prison. This is a picture of Chris with his parents while he was in prison in Texas. His co-defendant, Richard Danziger, was also convicted and sentenced to life in prison, in part on the basis of Chris's testimony implicating the two of them, which Chris was required to provide in order to get his plea bargain and avoid the death sentence. He spent 12 years in prison before he finally wrote to our project. And these are some excerpts from the letter he wrote, just saying, I'm in a Texas prison doing a life sentence for a murder I didn't commit. You're my last hope. There are many discrepancies. I'm an innocent man. Many of us have just about given up on the system. And so you see, I haven't given up on myself. I've just about given up on the system. You're my only hope. These letters are really hard to ignore or turn away. So we quickly assigned a law student to look into this case. And one of the first things she did was call the lawyer who had been appointed to represent Chris in the proceedings that led to his conviction. These are the handwritten notes that our student took. Her name was Wendy. You can see her, this is memos to John from Wendy. Wendy was the student, showing that on November 9th, 1999, she called this person, John Nate Stark. Mr. Stark was Chris Ochoa's lawyer at the time. And what was remarkable is when she started asking him questions about this case, this was Chris's own lawyer, mind you. What did he tell her? He said, there is not a chance that Ochoa is innocent. Chris's own lawyer telling us this. And he went on to say, the co-defendant Danziger had the gun and Ochoa's fingerprints were recovered from the gun. He said there was a witness who saw the two of them outside the Pizza Hut. He said that Chris lied to him, Stark, the lawyer, repeatedly, until eventually Chris admitted the crime, Chris decided to do the right thing and tell the truth. Well, wow, we were stunned, right? So we call up Chris and say, Chris, you didn't tell us about all this. What do you mean you're claiming to be innocent? And Chris's reaction was, I don't know what he's talking about. I don't know where he's getting all this. Please, you've got to believe me. That's not at all what happened. So we looked into it some further, and we found that not only were Chris's fingerprints not recovered from the gun, police had never recovered the gun at all. They had never found the murder weapon at all. And indeed, there were no witnesses who saw Ochoa and Danziger outside the Pizza Hut. We frankly have no idea where this lawyer was getting this stuff, whether he was making it up or whether his memory was tricking him into believing what he thought must have been true, since he advised Chris to plead guilty. But in any event, we continued going, and we asked for DNA testing on the bodily fluids recovered from Nancy DePriest's body. And in fact, when we look back at the record, we saw that at the time of the original conviction in 1988, a very early version of DNA testing, something called DQ alpha testing, had included Ochoa as a possible contributor to the bodily fluids found in the case. But this was a very rudimentary kind of DNA testing, so that in fact, 17% of the Hispanic population could have been a contributor. So it didn't identify him, but it supported his conviction. So then in 1999 and then into 2000, we did a more current, more modern, more refined version of DNA testing, something called RFLP, which stands for Restriction Fragment Length Polymorphism testing. And that testing conclusively excluded Chris Ochoa, excluded his co-defendant Richard Danziger, and in fact matched another man, a man named Akeem Joseph Marino, a guy who had gone on to commit another rape after this one that had landed him in prison for life. And while in prison, he had found religion and had begun confessing to everyone he could find that he was the one who committed this crime, and that he had no idea who Ochoa and Danziger were, but everyone pretty much roundly ignored his confession until the DNA testing came along and matched to him and proved that he was guilty. This is the scene in January 2001 when the judge, with the district attorney's agreement, declared Chris to be actually innocent and set him free. There he is embracing his mother. This again was after he'd served 12 years in prison. Remarkably, after Chris got out, he went back to college, got his college degree, then applied to law school. And this is Chris studying to become a lawyer in the library reading room at the University of Wisconsin Law School, where he went on to go to law school. He graduated, and there he is at his law school graduation in Wisconsin at the commencement, where he was elected by his classmates to be one of the commencement speakers. So that sort of illustrates how this can all work and the kinds of cases we were doing early on. One of the questions that a lot of folks raise, though, is, well, how big is this problem? And what we can tell you now is that we know of at least 375 people across the United States who, just like Chris Ochoa, were convicted of very serious crimes and then were exonerated by DNA evidence since 1989, because remember, 1989 was the year of the first DNA exoneration. That's 375 people we know with as much certainty as science can muster that they were stone cold innocent, didn't commit the crime, and then in fact, someone else committed the crime. And remember what Mr. Markman and Mr. Cassell had said in that quote I showed you earlier, that the risk of convicting the innocent is too minuscule to be of any concern in the debates about the death penalty. We now know that of those 375 people who were exonerated by DNA evidence alone, 21 of them at one point had been sentenced to die for these crimes that we now know they absolutely did not commit. But keep in mind, and here's some interesting little tidbits to think about as you think about the scope of the problem. Of these 375 DNA exonerees, that represents the total number of years that they've all served in prison for crimes they did not commit, is 5,284 years. These individuals, on average, served 14 years in prison for crimes they didn't commit before they were exonerated. They went into prison on average at about the age of 26 and a half, and they didn't come out till on average they were 43 years old. Think about all the human suffering and the loss that these people suffered during that time. When you look at the DNA, the demographics of the DNA exonerees, it's also rather striking and frankly very troubling. We know that Black people make up a fairly small percentage of the American population. They're disproportionately represented in prisons, but when you look at the exonerations, you can see that 60% of the DNA exonerations have been Black people who were wrongly convicted of crimes they didn't commit, compared to just 31% for white people. So we get a glimpse here that the DNA is showing us that the racially disparate patterns we see throughout our system are present when it comes to wrongful convictions. Black people are much more likely, at much greater risk of being wrongly convicted than are white people. Another way to look at this is if you look at the racial disparity by the kind of crime that's committed, especially look at the sexual assaults, which plays into a lot of the old stereotypes that afflict Black people quite unfairly. You see that particularly when it comes to sexual assaults, Black people are grossly disproportionately represented among the exonerees. So we've got DNA. We've solved the problem, right? Well, no, we haven't. And why is that? Because the DNA, as powerful as it is not present in most cases. And so it can't stop the wrongful conviction of most people. So one of the most important things we can do from these DNA exonerations is study them. It's for the first time in the history of our criminal justice system, we have a pool of cases, a body of cases in which we know with virtual scientific certainty, as much as we can muster, that we got it wrong, that our system convicted the wrong person. So we can study those cases and look at them and say, all right, well, what is it that keeps leading to these wrongful convictions? And when you look at the DNA exonerations, again, these are the cases where DNA proved innocence, we see that the most common feature, the most common contributing factor is eyewitness error. And that is not to say that lying witnesses. This is to say witnesses who simply made a mistake. They picked out the wrong person. Oops, usually trying to do it correctly, they just made a mistake and picked out the wrong person. Ironically and surprisingly, the second most common factor is flawed forensic science. I say ironically because here it is, forensic science in the form of DNA evidence that has led to the exoneration of these individuals. But it was also forensic science, typically other kinds of forensic sciences. And by that I mean things like fingerprints, tire impressions, shoe prints, bite marks, hair comparisons, and the list goes on. All of these kinds of things are the traditional kinds of forensic sciences. When we look at these cases, in 43% of these DNA exonerations, misleading, inaccurate, or invalidated forensic science evidence was used to help convict an innocent person. Shockingly, we see that false confessions, just as in Chris Ochoa's case, are a frequent contributor to wrongful convictions. 29% of the DNA exonerations involve confessions from people who absolutely did not commit the crime. And what makes this particularly counterintuitive and hard to get your head around is the fact that these DNA exonerations are all exonerations in the most serious types of cases. Literally 99% of these cases are rapes and murders, or rapes and murders. The most serious kinds of cases, the kind of thing that almost all of us would say, I would never confess to a rape or a murder I did not commit. And yet it happens. In 29% of the DNA exonerations, that was one of the contributing factors. So we realize that false confessions are a real problem. Something's going on. What is it about the way we obtain confessions that leads to these errors? And when you look at a case like Chris Ochoa's, we can find some answers. We know that police judged to an early conclusion that he must be guilty. based on their intuitions about his demeanor. That was wrong. We also know that they employed, in a very aggressive way, some of the standard kinds of interrogation techniques that law enforcement are often taught to use, where they shut off denials, they are very accusatory, they make the person feel like they're doomed, like their situation is hopeless, like they have no way out, and that their best path forward, the thing that they can do to help themselves the most, is to confess. And in fact, that's exactly what they did to Chris Ochoa. They convinced him that he would be convicted, that he was doomed, and that because they told him that they lied to him. Police can lie during interrogations. They lied to him and told him that his roommate, Richard Danziger, was spilling the beans and was going to implicate them both. They told him that they had an eyewitness. They told him that he failed a polygraph exam. They told him he would be executed if he didn't confess. They showed him pictures of the death chamber. They scared him to death. And then they said, but if you confess, you can cut a deal and you can spare your life. And it's that kind of pressure that works to induce even innocent people to confess to crimes they didn't commit. We see that 17% of these cases involve informants, people who are given a benefit in their own case in return for providing a statement. So, for example, somebody's in jail awaiting their own trial, and they know that they've been locked up with someone the government is trying to convict. They might come forward and say, hey, while I was locked up with that guy, he confessed to me. We know that those often are not true statements, but people make them in hopes of getting a deal in their own case as payment for that statement. Well, the data shows us that happens with some regularity. We also see repeatedly government misconduct, and we see bad defense counsel. Now, I don't have any statistics to attach to these because these are subjective judgments about when was the defense counsel bad, when was the government acting, misbehaving. So I don't provide statistics here, but I can tell you that these are both prevalent as well. Well, as I said, though, all we've talked about to date is the DNA exonerations. But those 375 DNA exonerations are really only scratching the surface. Why? Because, as I said, most cases don't have DNA evidence. As powerful as it is, it's not of any use in your drive-by shooting or your convenience store robbery where the perpetrator doesn't leave behind any biological evidence. And so, in most cases, we're not going to be able to use it to exonerate the wrongly convicted. Moreover, even in those cases where there was DNA evidence, only the very fortunate are able to use it to exonerate themselves, because you can only use it to exonerate in cases where the DNA was preserved for all those years when the person sat in prison, where the person was able to get access to help on the outside when they're almost always indigent. They have no right to the appointment of counsel any longer once they've been convicted. And without assistance, they have no way of getting access to the DNA, getting a court to order the DNA testing, to pay for the DNA testing and whatnot. So it's really only the lucky few who are able to use this. So we know that this 375 is a gross undercounting. There is another effort that's really important that's been going on for a number of years now that's been trying to catalog all of the exonerations that we can find throughout the country based on any kind of new evidence of innocence, not just DNA, but recantations, new documents, new videos, whatever it may be. And this is called the National Registry of Exonerations. And here's the webpage for it, but you can find it just with a Google search for National Registry of Exonerations. To date, they have found and counted 2,706 exonerations since 1989, which is sort of the cutoff point where they started looking. They will tell you this also is a gross undercounting because there is no systematic way to find these cases. They do it by searching the internet for media accounts, for whatever they can find to try to tell them about exonerations, but there's no question that they are only scratching the surface. There have been some academic attempts to calculate an error rate. It's a very difficult thing to do, but the best estimate that scholars have been able to come up with seems to be something in the neighborhood of about 3 to 5% of all convictions might be wrongful convictions. Now, So you might say, well, no, we get it right 95 to 97% of the time, not bad. But if you're one of those 3 to 5%, it's pretty awful. And if you look at it on a larger scale, we have in this country, we have about 2.3 million people in prison and jail. If it's 3% of those are innocent, that's 69,000 innocent people in prison. If it's 5% innocent people, that's 115,000 innocent people locked up. That's a lot of human suffering. We can also look and see where are these exonerations coming from. And as you can see from this map, by far, the highest number of exonerations that we know of anywhere in the country is in the state of Texas. And in part, that's not surprising because it's one of the largest population centers in the country. But, it still is by far outdoing the count in California with 223, or Illinois with 338, or New York with 303. And in part, that's a good news story, and in part, that's a bad news story. I mean, it's a bad news story because it reflects a high number, a fairly alarming rate of wrongful conviction in Texas. The good news side is it also suggests that maybe folks in Texas are doing a better job than in other places of finding these wrongful convictions. But regardless, the bottom line is that Texas is leading the way when it comes to exonerations in this country. This is some data that simply shows the rate of exonerations in this country since 1989. The blue line on the bottom shows you the rate of DNA exonerations. And remember, I told you it started out in 1989 with 2 down there in the lower left-hand corner. And then it didn't go up. I guess it went down to 1 in 1991, and then started a steady ascent after that every year as more and more people got into the act of looking for DNA exonerations. It went up. And about 1996, it started coming down. And what many of us thought at that time was that we were going to burn through the supply of DNA exonerations, because now that we were in the DNA era, prosecutors and defense lawyers were starting to use DNA before conviction. And so we were using DNA to weed out the innocent before they were ever convicted. And we thought, well, probably what that means is the number of cases where people were convicted in the old days, where there's still DNA evidence around that can be tested to prove innocence, that those would dry up and we'd run out of DNA cases. But as you can see, after a couple of years of sliding, the numbers started going up again. And while it's gone up and down for a while, we have stayed fairly steady at about 25 DNA exonerations a year. And how could that be? Well, there's several explanations for why that number has not gone down and disappeared like many of us thought it would. They include things like the growth of the Innocence Network. We have more and more projects out there using DNA to find DNA exonerations. So the more projects, the more you look, the more you find. But it also has to do with the fact that the technology is getting better. The technology is getting much more sensitive so that we are able to get DNA results now, today, in cases where the sample was not sufficient or was not of good enough quality to produce results. So as the technology gets better, we're able to actually go back and revisit old cases where the results were inconclusive. The red line then is the number of exonerations based on other kinds of evidence. And as you can see, that sort of bounced around a little bit, but really skyrocketed. It's come down a little bit in recent years. But generally, most of the new exonerations are arising because once we sort of burst that myth of invincibility, we burst that myth of infallibility in our criminal justice system, and people started looking at old cases to see if people were actually innocent, and using not just DNA evidence, we started finding a lot of cases of innocent people based on other kinds of evidence as well. So this gives you a little snapshot of the history and the current status of the wrongful conviction movement. We also can look at those exonerations from the National Register of Exonerations. Remember, the difference is these are cases where people were exonerated based not just on DNA, but on all kinds of new evidence of innocence. And here we see a slightly different alignment of contributing factors, but many of the same features. Mistaken eyewitness ID now falls to somewhere around 28% of the cases, not the 69% we see when we look only at DNA cases, but still a sizable contributor. We then see perjury or false accusation as the dominant contributing factor in most of these cases. That is, people just lying. Some of that will be the jailhouse informants that we talked about before, but some of it is other people who, for whatever reason, are simply lying and falsely accusing people. We see false confessions, again, somewhat reduced, but still a surprisingly significant proportion of all cases. We see false and misleading forensic evidence, still a significant factor. And then official misconduct is an enormous contributor based on the way that the researchers at the National Registry of Exoneration have evaluated those cases. One more word about the death penalty. Since 1973, counting all kinds of exonerations, we now know that more than 170 people were wrongly convicted and sentenced to death in the United States. 170 people on death row have been exonerated and proven to be innocent and let free. 13 of those people were on death row in Texas. Has anyone been executed who was actually innocent? The answer to that is almost certainly yes, but it's not crystal clear, because once somebody's executed, almost always the work on trying to investigate and exonerate ends, because the need is so much greater for doing this work on behalf of people who are still living. So we don't have clear answers on that, but almost certainly there have been people who are actually innocent who have been executed. So we've understood the sort of the trajectory now, the scope, the nature of the problem. What are we going to do about it? And I'm happy to tell you that the Innocence Movement has generated quite a lot of momentum for reforming our criminal justice system in ways that can improve its ability to distinguish the guilty from the innocent. And when you think of it that way, you can recognize that this is sort of, in many ways, this is a win-win proposition for the criminal justice system. By being more accurate in our ability to distinguish guilt from innocence, we not only can protect the innocent, but we can help us also convict the guilty. Because remember, every time you convict an innocent person, you're failing to convict the guilty. So one of the first reforms out of the chutes was laws that require preservation of physical evidence after conviction, and that provide a right to access that information to try to develop DNA profiles in cases where the DNA profiles might prove innocence. In around 2000, when my project was really getting going, there were only 2 states in the nation that had laws that required preservation of biological evidence and a right of access to DNA testing. That was New York and Illinois. Now, all 50 states, because of these DNA exonerations, all 50 states now require, to some degree or another, that biological evidence can be preserved after conviction so that it's available for testing, and then provide a right to test that evidence, to develop DNA evidence when that evidence in the context of the rest of the evidence in the case might prove actual innocence. We saw that eyewitness error is one of the leading contributors to wrongful convictions. Well, it turns out this is something that psychologists have been studying for a long, long time. And they've been warning the criminal justice system that human beings are just not very good at perceiving, remembering, and identifying the faces of strangers. And they've been talking about the kinds of things that can lead eyewitnesses astray and the kinds of things that we might do to reduce the chances that an eyewitness will make a mistake. And I think you're probably getting some specific sessions from others on this, so I won't go into it in detail. It's a very complicated matter. But basically, some of the reforms that have been recommended, and this is just a small number of them, include making sure that police instruct the witness appropriately so they don't suggest to them that they need to pick someone out from the lineup or who to pick out. It includes things like proper selection of fillers. Fillers are in a lineup or a photo array. Those are the faces you've presented there didn't commit the crime, but they're just there to make it a good multiple choice test. Police have often in the past not selected those very well, so that the procedure turns out to be very suggestive and leads the witnesses to focus on the suspect that they have in mind. Blinding procedures is probably the most important recommendation that psychologists have been teaching criminal justice practitioners about. And all this means is that for any kind of a testing procedure like this to be valid, you need to make sure that not only is the subject of the test, in this case the witness, not aware of what the preferred or known answer is before taking the test, but also the person administering the test shouldn't know who the suspect is in this scenario. So the officer administering the eyewitness ID procedure should be blind as to who the suspect is, because without that, it's just basic common human nature that the police officer will even unintentionally, and despite their best efforts, they're likely to leak clues to the witness as to which one they want to pick out, or to lead them to interpret the witness's responses in ways that are more incriminating towards the suspect than is really warranted. Sequential procedures is a complex matter. That one's a little bit more controversial, but that is a recommendation to change the psychology about the way witnesses pick people out by showing them faces or individuals one at a time instead of all as in a single array. And then one of the newer but more important recommendations also is you got to videotape the whole eyewitness ID procedure so you can see if there's any suggestiveness going on, and so you can see if the witness hesitated or really knew what was happening. So these are the kinds of things. Most police departments have not yet adopted these. Some states are requiring them, but they are absolutely gaining traction, and there's sort of momentum building to adopt these throughout the country. False confessions, like what happened to Chris Ochoa. Well, one of the things we know is that one of the most profound recommendations for reform there is to require electronic recording of custodial interrogations. That is, you videotape the interrogation of the suspect. Why? Well, it does several things. One, we're hoping that it will deter police from engaging in over-the-top coercive interrogation tactics because they know that it'll be caught on videotape. But we also, if police do engage in over-the-top tactics, we'll have a record of it, so we'll know to discount the confession to some degree. So, for example, in Chris Ochoa's case, what the police did was actually some of it was quite illegal. When he asked for a lawyer, they told him he couldn't have one. That was against the law. When they threatened him with the death penalty, that went too far. Our hope would be that they would have been deterred from doing that if they'd been recorded. But if they weren't deterred, we all would have seen it, and he could have litigated those issues with the court. Moreover, all those details in that single-spaced 5-page typewritten confession that only the perpetrator could have known, that is, only the perpetrator or the police could have known. And in fact, the elected district attorney of Travis County, Texas, upon reviewing this case afterward, concluded that all of those details came not from Chris, but from the police officers themselves. And so if we'd had a recording of that, we would have seen that the police were the only ones who knew anything about the details, and that they were the ones providing all of the details, and that we would have known that Chris's confession was meaningless. Innocence reforms also include what can we do about improving forensic science? And I'm happy to tell you that when it comes to forensic science reform, Texas is at the vanguard. Texas is taking the lead through a number of things. I've got this logo up here from the Houston Forensic Science Center. Houston had a terrible forensic science scandal some years back where the Houston Crime Laboratory was just a disaster and was producing wrongful convictions and inaccurate results by the fistful. That organization was disbanded and a new one was created, the Houston Forensic Science Center, which is, I think, by all accounts, the best forensic science laboratory in the country, at least among the states now, really leading the way, showing how real science can and should be done in the forensic laboratories. Texas is also leading the way by creating a forensic science commission that can go in and investigate claims of bad science and has been fairly effective at doing that. At the national level, we have in the Obama administration, they created a National Forensic Science Commission. In the Trump administration, they disbanded it. Many of us are hopeful that with the incoming administration that they will reconstitute a forensic science commission, because a lot of work is needed to improve forensic science evidence. And you don't just take my word for that. And you don't need to just base this on the fact that forensic science error is a leading contributor to wrongful convictions. In 2009, the National Academy of Sciences issued this report called Strengthening Forensic Science in the United States, A Path Forward. The National Academy of Sciences is the preeminent scientific authority in this country. And they did an exhaustive study of the forensic science disciplines in this country. And their conclusion is what I have in blue here. They wrote that with the exception of nuclear DNA analysis, that is DNA from the nucleus of the cell, with the exception of nuclear DNA analysis, no forensic method has been rigorously shown to have the capacity to consistently and with a high degree of certainty demonstrate a connection between evidence and a specific individual or source. In a nutshell, they went through most of the standard forensic science disciplines and found that they were insufficiently validated, they had no real scientific foundation, that claims were being made that were not scientifically sustainable, and they called for drastic re-examination and overhaul of forensic sciences in this country. That, by and large, has not happened across this country. That was not the last word, though. In September 2016, the President's Council of Advisors on Science and Technology issued this report, which we often refer to as the PCAST report, reiterating the findings of the National Academy of Sciences and basically urging courts to more seriously examine forensic science evidence before admitting it. I have to give a plug for my own group. This is another organization that I have helped co-found, the Center for Integrity in Forensic Sciences, which is dedicated to trying to improve the status of forensic evidence in our courts. You can see the website there, sifsjustice.org, if you want to poke around there and learn a little bit more about the problems and what we're doing to try to improve that. But let me illustrate with one more case what the nature of these problems are. This is a case of a young man named Robert Lee Stinson. Again, in the 1980s, it was a 1984 murder in Milwaukee. A year later, in 85, he was convicted of this murder and sexual assault and sentenced to life in prison. The case involved an older woman whose body was found lying in a backyard area near her own home, but Stinson was also a neighbor there. So it was in a backyard area that's sort of adjoining to both of their backyards. Again, police had no leads on it, but when they examined her body, they found what they thought looked to be human bite marks on her skin. And this is an image of what her skin looked like. This is an actual image from the crime scene evidence showing what looked to be bite marks. And so police presented that to a dentist. And the kind of dentist who does this kind of work is called a forensic odontologist. And this dentist looked at this and said, I think those are human bite marks. And he said, and I think I can figure out who did this. Whoever did this had an unusual set of dentition, an unusual set of teeth, someone with some irregular teeth. So find me somebody who could have done it with unusual teeth. So police literally went around the neighborhood talking to people, trying to get them to open their mouths to see if they had some irregular teeth. And Stinson had a very prominently missing front tooth that was broken off. And so they asked Stinson to come in and to give some photographs of his teeth and make molds of his teeth, and he complied. And they presented that to this forensic odontologist. And the odontologist examined, actually two of them, examined the bite marks and Stinson's dentition and said the bite marks, quote, had to have been made by teeth identical to Stinson's. They also said that no set of teeth are identical. So in other words, they're saying they had to have been made by Stinson's teeth. They said there was no margin for error in this. They said the bite mark evidence was overwhelming. There was no question it was a match. And so on the basis of that evidence, Stinson was convicted and sentenced to life in prison. This is essentially the kind of thing they did. On the left, you see an image of the bite marks from the woman's body. On the right, you see a picture of Stinson's teeth with the bite marks overlaid on top. And the dentist looked at it and said, look, they line up perfectly. It's a perfect match. It had to have come from him. Well, fast forward a number of years, and the Wisconsin Innocence Project got involved in the case. And one of the first things we did was call in some forensic odontologists to look at it. And they re-examined the bite marks using more modern techniques. And what they did was, in the lower left-hand corner you see here is what they used a computer to generate hollow volume outlines of the biting surfaces of the teeth. These are little circles that show where the teeth would make contact with the skin. The advantage of that is that you can then overlay the biting outlines on top of the bite mark, but get rid of the teeth so you can more clearly see what you're looking at. And when you do that on the lower right-hand side, you see that these teeth don't line up at all. There's all kinds of biting surfaces that have no match on the skin, and all kinds of bite marks on the skin that have no match on the biting surfaces of the teeth. Most prominently, perhaps that front tooth there, where there's sort of a jaggedy line drawn around it. That's to show where the tooth would be. It's a very pronounced bite mark there. He had no tooth there. And so we went back to the prosecutors and we said, look, this can't be him. If this is an exclusion, they went back to their odontologist and they came back and said, nope, he stands by it. He says it's still a match. So we went back and did DNA testing. And we got cuttings from the victim's shirt, and we had it tested in areas that tested positive for salivary amylase, which is a presumptive test for the presence of saliva. Then an even more modern kind of testing, something called STR, which stands for short tandem repeats. And what they found was that on those spots on the shirt, they got partial mixed profiles, meaning there was DNA from more than one person there. But no one person's DNA profile was complete, so it was kind of hard to tell it apart. But what they could say with certainty was that it all excluded Stinson. He could not have been the source of any of the DNA. So we took that back to the prosecutors, and they said, well, that doesn't matter. He still could have done it, and then we just didn't find his DNA. So we went back and did what's called YSTR testing, which is a kind of DNA testing that just targets DNA from men. It's only looking, because only men have a Y chromosome, only men can produce YSTR DNA. And so we did that. And again, multiple profiles. Again, all of it excluded Stinson. So by now, the prosecutors are starting to get a little more concerned about it. And they say, okay, well, we still think he's guilty, but we agree with you that this is important. A jury should probably hear this. So we'll agree to vacate his conviction and retry him. In the meantime, while the case was getting ready for retrial, we did more DNA testing on that shirt. And the analysts were able to come up with a complete single source STR DNA profile. And that full profile, again, didn't match Stinson. It came from someone else, but even more importantly, when they took that DNA profile and ran it through the what's called CODIS, it's the FBI's database of convicted offenders. When they ran that profile through CODIS, they got a hit. They matched it to another man, a guy named Moses Price, who by then was in prison for another serious crime, and who, when police told him about the DNA match, he confessed and explained in detail how he, in fact, had been the one who committed the crime. And so this is the day, 23 years after Robert Stinson was sent to prison for this crime that he did not commit, solely because of the bite mark evidence, the bad bite mark evidence. This is the day, 23 years later, when he walked free out of prison on a cold, snowy day in Wisconsin. There he is standing with the law students who worked to free him. Say a few words before I stop here about compensation, because that's another front on which reform has been moving forward. The reality is it's very hard for people who have been wrongly convicted to get compensation for the time they spent in prison. And that's because the state, the government, has what's known as sovereign immunity. Under that doctrine, you cannot sue the state unless the state gives permission. So a lawsuit against the state, by and large, is barred. Likewise, the individual actors in the criminal justice system have various degrees of immunity, that is, protection from lawsuits, including prosecutors, jurors, judges, the police. Some have absolute immunity, some have qualified immunity. But in any event, it makes it very hard to sue them. There are ways under federal civil rights laws to pierce those immunities and to be able to sue, but that requires a showing of deliberate violation of an individual's constitutional rights. And that's a very hard thing to prove, especially because the reality is in most of these cases, in some cases there's deliberate violations and some people have been successful in suing because of that. But in most of these cases, there's no intent to violate constitutional rights. There's no intent to frame an innocent person. Police and prosecutors think they're going after the right guy. They just make mistakes. And a mistake is not a basis for suing them for wrongful conviction. So given that, many states have now adopted statutes, laws. Their state legislatures create laws that provide ways for people to be compensated without suing. Wisconsin, for many, many years, has had such a statute, but it hasn't been updated in literally decades, and it is now among the very worst. It provides compensation, provides that a state claims board, if it's satisfied by clear and convincing evidence that someone was actually innocent and wrongly convicted, it can award compensation in the amount of $5,000 per year of wrongful imprisonment, but capped at a maximum of $25,000. So for Robert Lee Stinson, who spent 23 years in prison for a crime we know he didn't commit, the most the state claims board could give him was $25,000 for those 23 years. Now, fortunately, in that case, the Wisconsin legislature came back and passed a private bill to give him a little bit more. But even at that, it was still, I think, $90-some thousand, which I think most of us would think that we wouldn't trade 23 years of our lives for $90,000. Here's another bit of good news about Texas. Texas has one of the most generous compensation statutes in the country. Texas provides $80,000 per year of wrongful imprisonment, plus an annuity, that is an annual payout for life of $80,000, and a variety of kinds of reintegration assistance, payment for lost wages, and other things. So it provides, I believe, healthcare, education assistance, housing, a variety of things like that to help people get back on their feet. But the reality is, because these rules are so spotty from state to state, a huge proportion of the people who are wrongly convicted and then exonerated have not been compensated by one dime for their wrongful convictions. Last thing I want to talk to you about is innocence in prosecutors. The response we get from prosecutors to claims of actual innocence varies widely. In some cases, prosecutors fight tooth and nail to preserve wrongful convictions, even when the evidence is overwhelming that the person is actually innocent. In other places, on a case-by-case basis, they may agree. One of the most exciting and promising developments that's come along in recent years is that some prosecutors' offices have started creating what they call conviction integrity units. These are essentially innocence projects housed within a prosecutor's office. These are units within the prosecutor's office where the prosecutor says, we're going to affirmatively, proactively go back and examine our old cases to see if we made mistakes in any of our old cases. And if so, we're going to set those people free. Now, the great advantage of this is that because it's happening within the prosecutor's office, they have full access to all of the police files, all the prosecution files. There's no difficulty obtaining evidence. If they want something tested, they don't have to go get a court order. They can just do it. The disadvantage is that because they're in prosecutors' offices and prosecutors are part of an adversarial system, if they're not constructed properly, they run the risk of not actually looking very hard, of being disinclined to find error. So there are some projects that have been very successful and some that haven't. To date, we know of, across the country, 33 conviction integrity units where they have exonerated people by re-examining their old cases. We know of another 44 conviction integrity units where to date they have not exonerated anyone yet. And for some of these, it's just because they're too young, they're just getting started. For others, it may be because they don't have a very good system for reviewing the cases, or just bad luck, whatever. But there's a wide variety of experiences. But one of the things we found that is the most important to make sure that these projects are effective is that the prosecutor, that the lead district attorney will bring in to head up the office someone from outside the office who will have no reason to try to protect old convictions, and someone instead who maybe has an experience working with as an innocence advocate or working as a defense lawyer who knows how to look for evidence of actual innocence. Texas, again, has been sort of leading the way on this. The first such conviction integrity unit was created in Dallas County in 2007. And to date, that conviction integrity unit has exonerated 36 innocent people. Harris County in Houston was created 2 years later, and look at this. They have been so active that to date, they have exonerated 144 innocent people. This is the district attorney's office doing this. Tarrant County was created just a few years ago, 5 years ago. They've exonerated one person. And Travis County, created three years ago, has now exonerated two. And finally, Bexar County, created 2 years ago, has already exonerated 9 people. So you can see that there's still a lot of work to be done. There's a lot for the system to do to learn from these wrongful convictions, to protect the innocent, to make sure that we convict the guilty, and to work together, prosecutors, crime laboratories, defense lawyers, innocence organizations, to make sure that we exonerate those folks who are actually innocent and that we are not misled, misdirected away from pursuing the truly guilty. And so that is what I have to tell you here today, unless, Mark, you have some questions.
You know, there are so many instances where it is just in a person's, and I'm sure in the public defender's office, you saw this all the time, where a defendant considered to be worth his or her while to plead guilty to avoid the possible consequences of going to trial or taking a chance. And it may not be because they think they're guilty, but just because they're weighing the likelihood of success and are making a reasoned judgment that the better thing to do is to go ahead and plead it out.
Yeah.
And you know, our system is geared to promote and encourage plea bargains, and as long as that's the case, and there is an understanding, which I think is an absolutely true understanding, that those who are convicted at trial are going to be treated more severely in terms of punishment than those who plead guilty, there's going to remain that incentive to plead guilty, even if you're not necessarily guilty.
Yes, that's absolutely actually a very big problem. There is a well-documented, well-researched trial penalty. That is, people who go to trial can expect a harsher outcome if they're convicted than if they take a plea bargain. And the effect of that is indeed to put enormous pressure on people to take a plea bargain, even if they're actually innocent, in order to minimize the risks of an unacceptably harsh outcome. And we see that in a lot of research. We see that it's well documented. It's one of the most really troubling and mystifying, I mean, not mystifying, but one of the most least well understood, but really troubling aspects of our criminal justice system is that we don't have a trial system, really. 97% of all criminal convictions are obtained by plea bargain. These pressures come to bear on people to plead guilty even when they're innocent. And what I was getting at, one of the most overlooked things about that is that probably what that means is that as dramatic and profound as are the wrongful convictions in the big cases, which is what most of the data we have is based on, the biggest problem with wrongful convictions probably arises in little cases.
Right.
In run-of-the-mill routine misdemeanors. Why? Because the typical scenario is a poor person is charged with a misdemeanor or a small crime. They don't have the money to post bail. They sit in jail. The process takes a long time. Because it's a relatively small case, the plea bargain that's offered is plead guilty today and you'll get time served and you can go home. Or you can continue to fight it, insist on going to trial, and it'll take a long time and you'll sit in jail that whole time. Probably that's where most of the wrongful convictions in our system come from, but we have virtually no record of that because no one looks. They're not, because almost all of these people have already done their time, so nobody's reinvestigating them. There's so much need to help people who are facing big, heavy sentences that the resources aren't there to reopen and reinvestigate the little cases. So most of those fly under the radar, but that is almost certainly an enormous problem of wrongful convictions in our system.
And exacerbated even more by the fact that a reasonable lawyer representing a client in such a circumstance is, I would think, likely to say to the client, hey, you can get rid of this, just take this plea.
Absolutely. And go home. I've heard many a defense lawyer literally browbeat their client saying, you'd be a fool not to take this deal. You take this deal and you can go home. We can fight it, and then you're going to sit in jail for a lot longer, and you might even lose. And then you're really facing some bad time.
So you have in that situation, even the person who's charged with the responsibility to preserve the rights of the defendant, joining forces with a system that is geared to encourage an outcome that is not necessarily just.
And in fact, that's essentially what we saw in Chris Ochoa's case. His lawyer told him essentially, you've confessed. You signed a confession. You're going down. They're going to convict you. My job now my job is to save your life. And the way I can save your life is if you take a plea bargain to a life sentence. And so that's what he did.
Yeah. Wow. Well, fortunately, we have more and more people shining a light on the system and concerned about the outcomes. And we continue to look for not only the reasons why these mistakes occur, but how we can adjust the system to make it less likely that they will occur in the future. So we're hopefully addressing not just the identification of mistakes that have been made, but in a systemic way, a look at how we can avoid them in the future.
Absolutely. That's the ultimate goal.
Well, Keith, we are deeply in your debt for the good work you do, for the help you've given us in this program, and thank you very, very much.
You're so welcome, and thank you for inviting me and giving me a chance to present on this.